Hey, yo, folks, and welcome to an update on probate Judge Peterson, who you might remember from a few days ago when she got intoxicated for a fight and decided that was a good time to assault a cop, allegedly. Now, completely unrelated to this, Georgia Supreme Court is yeeting her out of the bench. Now, she already lost the re-elections, so it does not matter that much. But it does mean she can't do anything from today. Because Georgia Supreme Court says, you're out. So she can't collect all the fees that she has been doing for the last few years. No base salary, no nothing. She is out. Hopefully, this is also an indication from the court that we are not scared of cheating judges when they handle the Judge Glanville situation. But let's see how this happened. In the Supreme Court of Georgia decided June 25th, 2024, today, inquiry concerning Judge Christina Peterson, per curiam. We have explained before that the judiciary's judgment will be obeyed only so long as the public respects it. And that respect will not long survive judges who act in a manner that undermines public confidence in their judgment and integrity. In this case, Douglas County Probate Court Judge Christina Peterson has been charged with a number of violations of the Code of Judicial Conduct, the CJC, including a number of violations that the Judicial Qualifications Committee, the JQC, says exhibited a pattern of judicial misconduct while in office. The JQC hearing panel found that Judge Peterson violated multiple rules in the CJC and that those violations warrant her removal from the bench. We agree, we as in Georgia Supreme Court, that removal is warranted here. As we explain more below, the hearing panel found that the director proved by clear and convincing evidence 28 out of 30 counts, alleging that Judge Peterson violated the CJC and that discipline is authorized under the Georgia Constitution for 20 of those 28 counts. With respect to all of those counts, we conclude that the hearing panel's findings are not clearly erroneous, and we agree with and affirm the hearing panel's conclusion that Judge Peterson's misconduct was disciplined with respect to 12 of them, because the director met her burden of showing that Judge Peterson's conduct constituted willful misconduct in office or conduct prejudicial to the administration of justice, which brings the judicial office into disrepute. Now, folks, I didn't know all of this before she went haywire at a bar. I really didn't. But I am not surprised seeing how she conducted herself in the cop car and everything, how she threatened the cop, how she somehow thought that God was on her side. It seems like Judge Peterson, but we will get there. I will not spoil the surprise. The serious assertion of those violations, the pattern of misconduct the director proved by clear and convincing evidence, and the adverse demeanor and credibility determinations the hearing panel made after observing live testimony from Judge Peterson all contribute to the conclusion we reached today. Here it goes. Background and procedural history. Judge Peterson was admitted to the State Bar of Georgia in 2013, and on March 5th, 2020, she qualified to run for the office of Judge of the Douglas County Probate Court and therefore became a judicial candidate for purposes of the CJC. Well, these rules. In June 2020, she won a contested primary election. She then won the general election, in which she was unopposed, and she was sworn in for a 4-year term as the Douglas County Probate Court judge on December 29, 2020. In September 2021, not even a year later, the JQC filed formal charges against Judge Peterson alleging several violations of the CJC. The JQC amended its charges in February of 2022 and again in July of 2022. Amended the charges means they piled on, as in, hello, she's not doing good, alleging 50 counts of misconduct. The JQC director dismissed 20 counts before and during the final hearing, which was held over the course of 7 days beginning in September 2023, and concluding, this is a long footnote. I will just read the basis here. In February of 2024, leaving 30 counts remaining for the hearing panel's resolution. Now, remember, she started violating rules more or less the moment she took office. And here we are 4 years later, and now she's yeeted off the bench. Stuff takes time sometimes, folks. That's just the way it is. Hopefully, since Judge Glanville is a chief judge and his conduct has way larger bearing on the faith in the judicial system than a local probate judge, that will take weeks rather than years. The hearing panel issued a report and recommendation on March 31st, 2024, finding that the director had proven 28 of the 30 counts by clear and convincing evidence, but that discipline was authorized pursuant to the Georgia Constitution for only 20 of those counts. In so doing, the hearing panel concluded that Judge Peterson had violated multiple rules in the CJC and recommended as a sanction that this court remove her from office. Judge Peterson filed a notice of the exceptions to the report and recommendation, CJQC Rule 24F, arguing that the director had not sufficiently proven that she committed sanctionable conduct, and the director filed a response to those exceptions. Phase 2, analysis. As discussed more below, we agree with and affirm the hearing panel's conclusion that Judge Peterson's misconduct with respect to 12 of the 20 counts at issue here was proven by clear and convincing evidence and warrants discipline. Those counts relate to 4 separate matters, which include Judge Peterson's handling of a criminal contempt matter. All right. Certain aspects of her conduct towards county personnel. Her conduct during a meeting of her neighborhood homeowners association. Nobody can. This might be one of the good HOAs. And her handling for a petition for years support. And consider these. We discuss each of these 4 matters in turn below, applying the following analytical framework. First, we review the hearing panel's findings as to Judge Peterson's conduct with respect to each matter. Quote, we generally review factual findings by the JQC hearing panel for clear error and defer to the hearing panel's credibility determinations. Explaining that, quote, we give substantial consideration and due deference to the hearing panel's ability to evaluate the credibility of the witnesses who appear before it. Judge Peterson's primary argument in her exceptions to the report and recommendation is that the hearing panel's factual findings as to each of the matters at issue are clearly erroneous, because the panel either failed to credit or to expressly mention in its report and recommendation evidence that Judge Peterson says supported different findings. In this respect, Judge Peterson devotes dozens of pages in her exceptions to recounting this other evidence. But we need not and do not detail most of that evidence below. Thank you. Although Judge Peterson is correct that some of the evidence she notes, if credited by the hearing panel, could have supported different findings. The record in this case do not compel those different findings. To the extent the record contains evidence that could support findings in either direction, the hearing panel was authorized to make the findings that it did. Sorry. See Coomer, second, rejecting the judge's similar argument that evidence in the record could have supported different findings by the hearing panel because the record did not compel the different findings that he preferred. After thoroughly reviewing the record and the parties' briefing, we conclude that the findings in the hearing panel made that are material to our ultimate conclusion in this case are not clearly erroneous, and we defer to the findings that the hearing panel made as outlined below. Second, we consider whether these findings support the hearing panel's conclusion that Judge Peterson's actions with respect to each matter amounted to violations of the CJC rules the JQC charged. In considering whether the director has proven violations of the CJC, we employ a clear and convincing proof standard. And we review the hearing panel's legal determinations de novo. De novo means fresh, as in never heard before. This is completely fresh for the Georgia Supreme Court. As explained below, we agree with the hearing panel's conclusions that Judge Peterson violated multiple rules in the CJC. Third, our review of the hearing panel's findings and conclusions isn't necessarily conducted through the lens of the Georgia Constitution, and specifically the grounds for discipline that the Georgia Constitution authorizes. Article 6, Section 7, blah, 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 blah. Sets out five grounds for discipline: for willful misconduct in office, or for willful and persistent failure to perform the duties of office, or for habitual intemperance, or for conviction of a crime involving moral turpitude, or for conduct prejudicial to the administration of justice, which brings the judicial office into disrepute. So, I have a feeling she kind of knew this was coming, and she decided, I'm going to get drunk out of my mind, and we know what happened. As detailed below, we agree with the hearing panel's conclusion that paragraph 7 authorizes discipline against Judge Peterson for the counts discussed below, because the director has met her burden of proving that Judge Peterson's conduct with respect to each of the four matters at issue constitutes at least one constitutional basis that authorizes discipline, either willful misconduct in office or conduct prejudicial to the administration of justice, which brings the judicial office into disrepute. We then briefly review the hearing panel's findings as to the 8 remaining counts that the panel found were proven by clear and convincing evidence and warranted sanctions. Although those findings are not clearly erroneous, we need not decide whether the hearing panel correctly concluded that Judge Peterson's conduct as to those counts constituted violations of the CJC and warrants discipline, because affirmance of those counts is not necessary to reach our ultimate conclusion that Judge Peterson's removal from the bench is the proper sanction in this case. So 12 out of 20, then they stopped. We don't need the rest. We don't need the other 8. The first 12 are well within what we are going to do. Finally, after reviewing all of the conduct underlying Judge Peterson's numerous violations of the CJC, we assess the proper sanction. On that point, we agree with the hearing panel that removal from office is the appropriate discipline here. We now apply the analytical framework described above, beginning with an evaluation of the counts that the hearing panel found were proven by clear and convincing evidence and with which we agree warrant discipline. We address first the most troubling allegation: Judge Peterson's handling of a criminal contempt matter. This we need to listen to carefully, because this directly goes towards how they treat most handling of criminal contempt matters. And as you know, Judge Glanville, what he is in trouble for is not just the ex parte meeting, but him applying, judging Mr. Steele and finding him in criminal contempt. And clearly misunderstanding. Judge Glanville can't differentiate between civil contempt and criminal contempt. That is a huge issue, so this will be interesting. With respect to counts 31 to 34, the hearing panel found the following facts pertaining to Judge Peterson's handling of a criminal contempt matter. On August 2nd, 2021, a petitioner who is a naturalized United States citizen but born in Thailand filed in the Douglas County Probate Court a petition to amend her marriage license application, which she had filed with the court in May of 2016. The petitioner sought to correct the name she had listed as her father's name on the marriage license application. In support of her petition, the petitioner attached a copy of a birth certificate, which had been translated from Thai into English. The copy said the document was, quote, not recommended as a legal document, unquote. After reviewing the petition to amend, Judge Peterson issued on August 12, 2021, a, quote, notice of trial or hearing, unquote, which informed the petitioner that she was required to attend an in-person hearing, another similarity with the Judge Glanville thingy, on the petition on August 24th, and the court reporting services would be provided only if the petitioner arranged for them. All right. The notice made no mention of any charges of contempt and did not advise the petitioner that she was entitled to have counsel present. Jesus Christ. What's in the water in Georgia? Whatever it is, lower court judges drink too much of it. At a hearing on the petition to amend, which was not transcribed, the petitioner presented a copy of the translated birth certificate, and Judge Peterson concluded that it was, quote, fictitious, fraudulent, and forged. The petitioner explained to Judge Peterson that she previously has listed her uncle's name rather than her father's name on her marriage license application in 2016 because her father was not involved in her life and her uncle had raised her. Judge Peterson ultimately determined that the petitioner was trying to defraud the court and held her in contempt. Wow, Judge Peterson, you are not a nice person. The contempt order stated that the petitioner willfully provided false information on the marriage application. The court had been alerted to the fraudulent misrepresentation on August 2nd, 2021, when the petitioner filed a petition to amend marriage record. And the petitioner was, quote, in blatant disregard of the laws of the state of Georgia and of this court, evidenced by her fraudulent misrepresentation to the court via her filings with the court. I kind of want to look up what that case. I have a vague recollection about somebody in chat mentioning this. Judge Peterson sentenced the petitioner to the maximum allowable term of incarceration for contempt, 20 days in jail, but allowed her to, quote-unquote, purge herself of the contempt order after serving 2 days if she paid a $500 fine. Remember, folks, Judge Peterson kept all the fees. And I assume she wanted a new purse or something, and she decided, yeah, I'm going to get it from here. After the petitioner served 2 days in the Douglas County Jail and paid a $500 fine, she was released from custody. The hearing panel found that Judge Peterson, quote, provided neither a firm nor a proper basis when she held the petitioner in contempt and without explanation or justification imposed the maximum term of incarceration plus a fine. It determined that the petitioner who testified before the panel was, quote, in good faith trying to correct, end quote, what appeared to be, quote, an innocent mistake born out of ignorance rather than ill intent, end quote. The hearing panel noted that Judge Peterson testified that the petitioner sought to amend the marriage license application so that her mother could emigrate to Thailand from Thailand to the United States. Although Judge Peterson could not explain how the amendment would assist the petitioner in obtaining immigration documents for her mother. Yeah, I mean, her marriage certificate, who's listed on them as her father, has no bearing whatsoever on if her mother can come to the United States. Whereas the petitioner testified that she became aware of the mistake on her marriage license application while she was completing immigration documents for her mother and believed she should correct the application so that it would not be inconsistent with her birth certificate. The hearing panel expressly credited the petitioner's testimony over Judge Peterson. In addition, the hearing panel expressly discredited Judge Peterson's testimony that she had not concluded that the petitioner made fraudulent representation before issuing the notice of the hearing on the petition. In this respect, the hearing panel found that Judge Peterson, quote, predetermined that the petitioner had made a fraudulent misrepresentation via her filings with the court on May 3rd of 2016 before ever conducting a hearing on the matter. Do you recognize that? A judge forming conclusions before the hearing. Exactly what happened when Mr. Steele was found in contempt by Judge Glanville. If this is indicative of how the Georgia Supreme Court sees these kinds of issues, Judge Glanville might be in a world of trouble. The hearing panel noted that Judge Peterson denied making any such predetermination and testified before the panel that she found the petitioner in contempt based on her submission of the supposedly fictitious birth certificate at the hearing on the petition. But the panel found that testimony to be false because it, quote, contradicted the plain language of the order, end quote, which referred only to the alleged fraudulent misrepresentations in the marriage application. Because evidence presented at the hearing supports the hearing panel findings that are material to our ultimate conclusion, those findings, as recounted above, are not clearly erroneous. The hearing panel concluded that the director proved by clear and convincing evidence that Judge Peterson violated CJC rules, this and this and this. We agree. To begin, the hearing panel credited the petitioner's testimony over Judge Peterson's account and found that in attempting to amend her marriage license application, the petitioner was in good faith trying to correct an innocent mistake. After affording proper deference to that credibility determination, it is clear to this court that Judge Peterson's contempt ruling was baseless. In response to the petitioner's good faith effort to amend her application so that it would not be inconsistent with her birth certificate, Judge Peterson made an substantiated finding that the petitioner was somehow attempting to defraud the court, and then unjustifiable held her in contempt. Indeed, the hearing panel determined that Judge Peterson, in testifying before the panel, lied about the basis for her contempt ruling when she repeatedly referenced her belief that the translated birth certificate was fraudulent, notwithstanding that her written contempt order focused only on the alleged fraudulent misrepresentations in the marriage license application, not the birth certificate. Judge Peterson's untruthful testimony in this respect underscores her conscious wrongdoing in determining what the petitioner had defrauded the court before issuing the notice of the hearing on the petition. Because, as the hearing panel found, Judge Peterson purposely issued the notice without advising the petitioner that a criminal contempt charge on the allegation of fraud would be adjudicated at the hearing, so that the petitioner would be unprepared to defend herself when Judge Peterson summarily found her guilty of criminal contempt. As we explain below, these actions of misconduct evinced a willful disregard for the basic requirements of due process. I hope to everybody that Georgia Supreme Court uses the exact same standard when Judge Glanville's case comes before them, because there are too many similarities between this case, in that specific case, in the case. They're too similar. And it's good that it arrived now, because now now Mr. Weinstein, Mr. Steele, Mr. Chad, all the others can reference this finding when they bring Judge Glanville before the Georgia Supreme Court. Oof. It is well established that criminal contempt is a crime in the ordinary sense, and criminal penalties may not be imposed on someone who has not been afforded the protections that the Constitution requires of such criminal proceedings. Yeah, remember Miss Merchant telling Judge Glanville, you can do this. When you decided Mr. Steele was risking criminal contempt, he had constitutional right to representation, which Judge Glanville tried to ignore. In this respect, although a judge may announce punishment summarily and further without further notice or hearing when, quote, contumacious conduct, end quote, occurs in the judge's presence and threatens the court's immediate ability to conduct its proceedings, such as where a witness refuses to testify or a party disrupts a court. Yeah, exact same standard as in the case against Judge Glanville. I'm going to skip over because I'm so interested. This is my first reading, folks. This is my first reading, and I really, because they are talking a lot about this contempt order, and yeah, I want to hear about the other things she did. Her willful misconduct in office. This is good. The hearing panel found that Judge Peterson's actions regarding this incident constituted willful misconduct in office because she acted in bad faith. I would assume Judge Glanville is also acting in bad faith. This is a lot of Let's see here while I scroll. With respect to counts 28 and 30 conduct toward county personnel, the hearing panel found as follows. By way of background, in April 2021, the Chief Judge of the Douglas County Superior Court limited Judge Peterson's after-hours access to the Douglas County Courthouse following an incident in which she allegedly improperly admitted public citizens to the courthouse without ensuring they had undergone security screening by sheriff's deputies. During the days in which her after-hours access to the courthouse was limited, Judge Peterson submitted 3, quote, event worksheets, each of which requested 3 sheriff's deputies to be present at the courthouse after it was closed to the public so that she could have after-hours access. Oh, Jesus Christ. Judge Peterson, or now former Judge Peterson, what did you... You invited friends into the courthouse for what? Drinks and gangbang? I don't know. I don't care. You just don't do it. So she ordered sheriff's deputies to be there so she could be there after hours. Although these, a lot of overtime, which taxpayer had to pay for. Judge Peterson was unable to provide a particular reason why she needed to be physically present in the courthouse at those times, most of which were overnight. Overnight, folks. Was there a gangbang in the courthouse, Judge Peterson? What did you do in the courthouse overnight? Party? OnlyFans? I don't know. It's pure speculation. Pure speculation. Fun speculation. Although Judge Peterson argues in her exceptions that she often worked later than regular court hours and that her testimony on that point showed that her request for after-hours access of the to the courthouse and the presence of security were legitimate, and she also admits that the request might not have been the most appropriate response. What's your guess, folks? What did she do? Keep it somewhat clean in the comment section. Keep it somewhat clean, please. Now, I can ruin my ad thingy with YouTube's, but please don't. You please don't. The hearings panel expressly noted Judge Peterson's testimony about these requests and found that Judge Peterson, quote, never put forth a particular reason why she needed to be physically present inside the courthouse on the dates and times she requested. Maybe she was scared to, because maybe it's on OnlyFans. I have no idea. I have no idea why she thought she had to be there. Sorry. In a separate event related to Judge Peterson's treatment of courthouse personnel, the sheriff deputy, who was scheduled to escort Judge Peterson from his chambers to her courtroom on May 11th, 2021, did not arrive in Judge Peterson's chambers on time. Believing that she would be late for court, she pushed the panic button under her desk to summon the deputy. Thinking there was an emergency in Judge Peterson's chambers, sheriff deputies hurried to her chambers. What entitlement! They were not there on time, so you pressed the panic button? Jeez, no! When they arrived, they realized there was no emergency. At her hearing before the hearing panel, Judge Peterson testified that she did not know the button was a panic button that was to be used only in emergencies. What did you think it was? Ding, 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 servant? Ding, 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 peasants? What? I can guarantee you that when she took office, somebody showed her that button and said, that is a panic button. If for any reason you're in here with a defendant, lawyer, prosecutor, and the defendant tries to jump you, you have a panic button. I'm 100% confident she knew. The hearing panel expressly discredited Judge Peterson's testimony on that point. Yeah, I should just have kept reading. After reviewing the record and considering Judge Peterson's exceptions, we cannot say that the hearing panel findings as to these incidents, which are supported by record evidence, are clearly erroneous. Nope. With respect to count 28, the accusee charged Judge Peterson with violating CJC rule blah blah blah, alleging that her request for after-hours court access and her activation of the panic button when there was no emergency were not in accordance with the high standards of conduct necessary to preserve the independence, integrity, and impartiality of the judiciary. Yeah, but we saw that kind of entitlement in the squad car as well. She honestly believes that she had, this is some kind of God complex with her. She believes that she deserves everything. And anybody standing in her way, I don't know. Napoleon complex, I don't know. Let's see the next thing here. The Georgia Constitution. I want to see the other things. Oh. With respect to count 13 to 15, the hearing panel found the following pertaining to Judge Peterson's conduct during a meeting of a neighborhood HOA in March 2022. Judge Peterson, representing herself, filed a lawsuit against the HOA and members of the HOA Board of Directors in July of 2021. The lawsuit alleged, among other things, that the defendants had breached the HOA bylaws by holding an improper election to select the Board of Directors and sought an injunction to compel a special election in accordance with the bylaws. Judge Peterson knew that the defendants were represented by counsel. On March 31st, 2022, while her lawsuit was still pending, Judge Peterson attended an HOA meeting over which 2 members of the board of directors presided. The meeting was video recorded, and the record showed that during the meeting, Judge Peterson asked the 2 members of the board of directors questions about her lawsuit, urged them to call a special election, and offered to dismiss the lawsuit if they did so. Oh no, you can't do that. If you are in active litigation, you cannot go to the counterpart without lawyer present. You cannot do. You're a lawyer, Miss Peterson. You were a judge. You know this. And then offer to dismiss the lawsuit if they did so. That is coercion. This is starting to look like the DA. Well, we know that the Phony Willis won't do anything. We already know that. When other meeting attendees spoke out against Judge Peterson, she engaged in hostile exchanges and made sarcastic remarks towards them, such as, "You are in a low place." After the meeting, Judge Peterson told the members of the board of directors that their counsel was giving them bad legal advice. You are not in that position, former Judge Peterson. The hearing panel findings, as summarized above, are not clearly erroneous because there was evidence presented at the hearing to support them. We agree with the hearing panel's conclusion that Judge Peterson's conduct in connection with this incident violated CDC Rule 1.1, Count 13. The hearing panel determined that Judge Peterson failed to, quote, respect and comply with the law, end quote. Rule 4.2 of the Georgia Rules of Professional Conduct for Lawyers, which says a lawyer who is representing a client in a matter shall not communicate about the subject of the representation with a person the lawyer knows to be represented by another lawyer in the matter, unless the lawyer has the consent of the other lawyer or is authorized to do so by law or court order. This is criminal conduct. By telling the 2 members of the HOA board of directors that she would dismiss her lawsuit against the HOA and the board if they held a special election, Judge Peterson, who was acting as her own lawyer, in the matter, communicated and even attempted to negotiate with parties to the lawsuit, even though she knew they were represented by counsel. As a result, she violated 4.2a. Nothing her testimony at the hearing that her comment about dismissing the lawsuit was not meant to be a formal offer, and that she did not actually believe that the 2 members of the board of directors had the actual authority to settle the lawsuit, because, as her lawsuit alleged, they were not properly elected. Judge Peterson asserts in her exceptions that she did not violate 4.2 because she was acting as a homeowner, not a lawyer, when she offered to dismiss the lawsuit. No. That's not how it works. Former Judge Peterson. Once you are on court filing representing yourself in a lawsuit, everything you do which involves the counterpart, you act as your own lawyer. But the hearing panel rejected that version of Judge Peterson's testimony, expressly discrediting her, quote, feigned ignorance, unquote, and instead finding that she was an experienced attorney who knew that the lawsuit she personally brought was still pending and that the defendants were represented by counsel. Oh, this woman is a moron. Okay, let's find the next one. Let's find the next one. Okay, handling of a petition for years support. The hearing panel's finding, with respect to count 35 and counts 37 to 43. The hearing panel found the following facts pertaining to Judge Peterson's handling of a petition for years support in the spring and summer of 2021. In early 2021, a petitioner filed the petition for years support, seeking to obtain funds from her deceased husband's estate. The petition listed the petitioner's daughter as an interested party and provided her out-of-state address. Judge Peterson's chief clerk sent by certified mail, with restricted delivery, a notice of the petition to the address that was provided for the daughter. The notice set the deadline to submit the caveat to the petition by May 3rd. On April 5th, the signature card for the certified delivery of the notice of the petition was returned to the probate court with a signature from someone else, not the daughter. Oh no. No. I don't want to read this. No. Judge Peterson's chief clerk then asked Judge Peterson to search Lexi's to try to obtain an alternate address for the daughter. No, you can't do that. Judge Peterson conducted the search and found the daughter's email address. Judge Peterson's chief clerk emailed a second notice to the daughter, setting a new deadline to file a caveat by July 10th. The daughter eventually emailed her caveat to the probate court clerk's office. The chief clerk and the daughter then spoke by phone, and the chief clerk asked about the status of the original document and the filing fee, which were both required for filing. The daughter said she mailed the filing fee. The chief clerk assumed that it was lost in the mail and ultimately took payment from the daughter over the phone and filed a caveat on July 14, 4 days after the July 10 deadline. None of the chief clerk's communication with the daughter included counsel for the petitioner. What the actual frick? Is Judge Peterson's chief clerk a friend of hers? It sounds like it. The hearing panel found that although Judge Peterson's staff, including the chief clerk, knew that ex parte communication with parties to a proceeding were prohibited, Judge Peterson clearly failed to conduct proper oversight to ensure that the chief clerk was not participating in such communication. Oh no. The petitioner's counsel filed a motion to strike the caveat as untimely, and Judge Peterson denied it. Judge Peterson later recused herself from the case, which was eventually transferred to Douglas County Superior Court. That court struck the caveat as untimely and granted the petition for year support about 15 months after it was first filed. The record supports the findings summarized above, so we conclude they are not clearly erroneous. Oh, yes. Former Judge Peterson is not... she went through law school and everything and still is such a moron. Let's move on to the next one and see what that will. Dun, dun, dun. Dun, dun, dun. Dun, dun, dun. Other alleged violation found by the hearing panel, which we declined to consider. In addition to the violation of the CJC that we determined above that Judge Peterson committed and for which she may be disciplined pursuant to paragraph 7, the hearing panel concluded that the director proved by clear and convincing evidence 8 other counts in the formal charges. We briefly discussed below the hearing panel findings, which we determined are not clearly erroneous as to these counts, but ultimately we need not decide whether the panel correctly determined that the conduct underlying those counts constituted violations, because the affirmance of those counts is not necessary to reach the conclusion that Judge Peterson's removal from the bench is the appropriate sanction in this case. As to Judge Peterson's conduct at the HOA meeting, okay, we already know that. Year support, we know that. Dun, dun, dun. In addition, hearing panel find findings to a separate incident involving Judge Peterson's conduct in allowing a party to a wedding over which she was scheduled to preside to enter the Douglas County Courthouse while the courthouse was closed, without ensuring that the party underwent security screening by sheriff's deputies, in contravention of an express directive from the Division Commander for Court Services with the Douglas County Sheriff's Office, not to allow the party inside. But the judge, no, I know better. I'm going to let them in. No, you don't do that. Finally, the hearing panel concluded that Judge Peterson violated 2.4, as alleged in count 50 of the formal charges by persistently and continuously failing to respect and comply with the law, and the CJC, as alleged in the count 16 through 49 above, demonstrating systemic judicial incompetence and disregard for the law. Ooh. Yeah, that's harsh. That's really harsh. The hearing panel's factual findings with respect to counts 14, 15, 19, 21, 38, 41, 43, and 50 generally are supported by the evidence presented as the hearings, but we need not decide whether the hearing panel, they clearly say, we have all we need. We don't need to address the rest. And then they go to point 3 here, removal is the appropriate sanction. And let's see, skimming through here. Yeah, this is about the rules of conduct for both as a lawyer and as a judge. And she didn't. And she testified. She was, when she went before the Georgia Supreme Court to testify, she lied to them. That's not a brilliant move, former Judge Peterson. But this is not. Yeah, removed from office. All justices concur except Colvin J. disqualified. Yeah, disqualified means that he removed himself from this issue for reasons unknown. Peterson, presiding justice, concurring, and this is his opinion, but we really don't need. Yeah. So, but this. Yeah, I mean, seriously. She took office and immediately she enriched herself. She first got a raise. Then she kept all the fees, which in 2021 alone, her base salary was roughly $140,000, and the fees collected by birth certificates, death certificates, stuff like that, another $130,000. She probably is the highest paid judge, or was the highest paid judge in Georgia, but not anymore. Georgia Supreme Court yeeted her behind out of there. And they did good. And I will go through this more thoroughly by myself. But what's very, very interesting is how much of what she did applies to Judge Glanville's case, especially the mishandling of the contempt, of the finding of contempt of Mr. Steele, Attorney Steele. It will be interesting because I assume the lawyers in the Young Thug case will use this when they bring the matter to the Georgia Supreme Court. But that is all I had for you. Judge Peterson, no longer a judge. Yeeted. But it took a few years. Hopefully, it won't take years before Judge Glanville is out of office as well. Thank you for being here, folks. Hit the like button on your way out. If you haven't subscribed yet, please do so. And if there are any updates, if Judge Peterson, whatever happens to her, I really, really don't care. As long as she's out of there. But if you want to, send me the stuff you want me to take a look at. And I will. Okay? Thank you.
Bye-bye.